This video is going to discuss wrongful death and survival acts. Wrongful death and survival acts are a basis for recovering compensatory damages under tort. Our case, the DeLong case, involved a woman who was killed by an intruder. She called 911. The dispatcher handled it negligently, which precluded the timely arrival of the police, and she suffered in those 12 minutes. However, she died. So why are we dealing with this case? Who is suing if she's dead? Well, the decedent's estate is suing. So DeLong's estate is suing under torts, negligence specifically, using the cause of action under the survival acts. And survival acts allow a decedent's estate to sue for pre-death injuries suffered by the decedent. The other plaintiffs include the surviving spouse and children, and they're suing under wrongful death, which is also under torts. Wrongful death is a cause of action that allows surviving spouses and minor children to sue for injuries suffered by them as a result of the decedent's death. And so these are usually both two types of statutes that allow these injured plaintiffs to claim compensatory damages. In this case, the lower court decided that it was going to award $200,000 for conscious pain and suffering to the decedent's estate, DeLong's estate, and $600K for the value of services provided by a housewife that now the surviving spouse no longer has because DeLong died. The issues before the appellate court are now, one, is the $200K award for conscious pain and suffering excessive? Was the $600K for the value of services provided by a housewife excessive? And was the expert testimony concerning the value of the services performed by a housewife incorrectly admitted? So all the issues before the court are step 2 issues, where we're deciding how to measure this pain and suffering and value of services, not step 1. A step 1 issue would involve whether the plaintiffs are entitled to compensatory damages under the survival acts and wrongful death statutes, which is the only time you really have to discuss the underlying claim in a little bit more detail in this course. So what was the appellate court's holding on each of these 3 issues? Well, it answered no in each case. Let's start with the first issue. The rule used to determine how much to award for pain and suffering when you're dealing with a decedent's estate was a very fluffy rule. The court said the award must not be disproportionate to the injuries. It must be within reasonable bounds. This is very similar to the rule that we had in our last video, which is pretty much there are no fixed or absolute standards. It's just reasonable. And then the dissent saying that it cannot exceed a part of the attributable to pecuniary losses, right? So it has to be reasonable. And the standard of review is it doesn't shock the conscience. And so here, again, it's not disproportionate. It seems fair. 12 minutes of terror she experienced when trying to save herself and her child. $200K, they determined, well, that's reasonable. The second issue, which is the $600K for the value of the services, was a little bit more complicated. The rule used to determine how much to award the surviving spouse for the wrongful death of DeLong was a fair and just compensation standard for any pecuniary injuries resulting from her death. Did they limit the recovery to pecuniary losses like the dissent opinion did for pain and suffering? The answer was no. A spouse can recover for parental nurture and care, for physical, moral, and intellectual training, and loss of those benefits, which is more similar to our broad rule that there are no fixed and absolute standards. Now, what were the factors the court said that must be used to determine the value of services that DeLong was performing as a housewife? Because in this case, we don't have any actual wages or lost wages. Well, first, the court stated that we have to look at each case on its own merit, and then laid out 5 different factors: her age, the relationship to the person seeking recovery, her earning capacity, life expectancy, and expert testimony. And you analyze this on a case-by-case basis, which led us to the third issue, which is whether the expert testimony was allowed to be admitted as one of the factors. And the expert testimony in this case said that the value of her services was over $500,000. The dissent determined that expert testimony was not admissible, while the majority said it was admissible. And the reasoning behind each group's opinion was the dissent said expert testimony is not admissible if it is within the general knowledge of the jury, But the majority determined that a jury would not be able to make these complicated economic calculations to determine how much she would have offered as a housewife for the remainder of her life. Because if we look at it, she was only 28 years old. Her husband was 28 years old. She had three children. She's raising the children. She cooks, cleans, housekeeping, does bookkeeping, makes the children's clothes. Figuring out that value would be hard for a layperson, according to the majority opinion. Main takeaways from this case: you have two bases to collect compensatory damages: survival acts and wrongful death. Under survival acts, the decedent's estate sues, and they can sue for the pain and suffering, loss of enjoyment, lost wages, medical expenses, funeral expenses. Those are just examples. Under wrongful death is where the surviving spouses and children will sue, and they have two categories, which is pecuniary, lost wages, value of services are examples, and non-pecuniary losses, which are like pain and suffering and loss of consortium, which we'll talk about in a future class.